Well, thank you all for coming. I know nothing says let's have a good time like going down to church on a Tuesday night to talk about death, but if you can contain your excitement, we'll make it through. So I'm just going to offer a little bit of an overview on estate planning and how documents are utilized before I pass it over to Chris. So your estate plan is beneficial after your death, but it's also beneficial during your life. So the four main estate planning documents I usually recommend to my clients are a will, and then two powers of attorney, one for financial decisions, one for medical decisions, and then a living will, which handles end-of-life medical care. So with a will, as you may know, you can distribute your assets to a single individual, a charity, or multiple individuals or charities if you would like. You can give gifts of percentages or lump sums. You can also use your will to make specific gifts if you have personal property in your home, like jewelry or family heirlooms, things like that. You can specify those in your wills. Parents of young children often use a will to establish a guardian for their children if they should pass before their kids reach 18. Parents also might use a will to establish what's called a testamentary trust, which is a trust that springs into being upon the death of the parents if children are still of a young age. And parents can appoint a trustee to manage assets for their children until they reach a certain age with that, with a testamentary trust. Your will can also be used to establish an executor or personal representative. That person will be in charge of distributing your assets according to the terms of your will. So if you do not have a will, your assets will be distributed according to Indiana intestacy laws, which means likely your assets would go to your family members. Also, if you don't have a will, a probate court will appoint an executor for you. So someone that you have not chosen will be in charge of distributing your assets. So for those two reasons, a will is really important to have. So I'll move on to the powers of attorney. So powers of attorney are only valid during your life. So upon your death, a power of attorney becomes totally invalid and ineffective. It cannot be used anymore. A financial power of attorney allows someone to handle your personal business if you can't handle those things on your own, such as your banking, paying your bills, depositing checks, things like that. A financial power of attorney can take effect immediately, or it could be a springing power of attorney, which only takes effect upon your incapacity. So often spouses are primary POAs for each other. In that case, I would probably have the power of attorney go into effect immediately. That way spouses don't have to prove incapacity to handle business for each other. But if you don't have a spouse, or if you're having another family member or friend handle your personal business, your POA could go into effect only upon your incapacity. If you do not have a financial power of attorney and you do lose capacity to handle your personal business, a probate court would have to appoint a guardian or a conservator for you to handle those things on your behalf. So that process becomes a little more complicated if you don't have something in writing saying what will happen if you cannot handle those things on your own. A healthcare power of attorney goes into effect if you are incapable of making your own medical decisions. So again, typically spouses are primary agents for each other, but you can always appoint backups if you'd like. I often have clients who have a family member in the medical field who choose to have that family member as their primary decision maker. So it's up to you. If you do not have a healthcare power of attorney and something happens and you can't make your own medical decisions, under Indiana law, your closest family members make those decisions for you, and it goes down through the layers of kinship. So if you want to make sure someone you trust is making those decisions on your behalf, you want to make sure you have the POA in place. A living will comes into play if you're in a terminal state and you're incapable of making decisions on your own. So you can use a living will to say, I do not want to be kept alive, I don't want life-prolonging care, I just want to receive comfort care and be allowed to pass. If you don't have a living will, your healthcare power of attorney will make those decisions for you, which is perfectly fine if you'd like to do that. But setting up a living will is a way to take that decision out of their hands if you would like to. So a lot of times parents don't want to leave that decision up to their children. They don't want them to feel that guilt over making that end-of-life care decision. So you might kind of be getting the idea that these documents are really a guide to help your family down the road. This can help, setting up these documents can help reduce confusion. It can prevent, debate and argument amongst your family members as to who's supposed to be making decisions, what decisions would you want to be made, who's going to get, mom or dad's assets or car or other personal belongings. So when people are grieving, leaving them to have to sort these sorts of things out can just serve to exacerbate the problem. So I kind of see your estate plan as a gift to your family to take these hard decisions out of their hands, and to make sure your children aren't fighting, they're not resenting each other, and your children don't have to feel guilt about trying to make decisions and wondering if they fulfilled what your wishes would be. And also communicating your estate plan to your loved ones is a huge part of the estate plan. You want to make sure that you have those hard conversations now, because say you leave someone out of your estate plan, or there's an unequal distribution, or you've chosen someone to be in charge, down the road, loved ones might wonder why you made those decisions, why they were left out. So it's a good idea to explain why you made those decisions now, so that there's not question down the road or no hard feelings about what decisions have been made. And it's also a good idea not to leave things up to surprise for your children. I had a palliative care doctor tell me, please tell your clients to talk to their families about the decisions that they've made, because he would have so many family members come in and their loved one had made end-of-life care decisions that were a total surprise. And so family members weren't happy and they were questioning things, and there's a lot of argument involved. So it can really help your loved ones down the road to put these documents together. I'm just going to touch on the probate process and trust briefly, and then I'll pass it off to Chris. So the probate process is the process through which an executor manages the distribution of an estate on behalf of the person who appointed them. So probate can include some filing and attorney fees that can get costly, especially if there's no will and everybody's kind of starting from scratch. So a lot of times you might hear people try to avoid probate. There are two main ways to avoid probate. One would be to set up beneficiaries on all of your assets, and the other would be to use a trust. So if you go with the beneficiary route, anytime you have an asset that has a beneficiary, like a life insurance policy, retirement account, investment account, that asset transfers to your beneficiary automatically. It does not have to go through the probate process. It also trumps your will. So if you have a beneficiary listed on any sort of account, you want to make sure that that goes in line with what you want done through your will. A lot of people aren't aware that even checking and savings accounts can be made POD or payable on death to a beneficiary, which would take those accounts out of the probate process. Real estate and vehicles can also be made to transfer on death or TOD to a beneficiary. That way a home or a vehicle can transfer to someone outside of the probate process again. And this is kind of the route I push for my clients who have simple situations. But trusts are also used. Trusts are a larger document that stipulate what happens to your assets both during your life and after you pass away. So you set up a trust and then you transfer your assets into that trust through retitling your home or making the trust the owner of your accounts. You could also make your trust the beneficiary on certain accounts. And then during your life with a revocable trust, you're typically the trustee and beneficiary of your own trust, meaning you get to control the trust and you get to use all the assets in the trust. And then upon your passing, the terms of the trust will stipulate how your assets will be distributed, whether that's immediately or over time. Some people will use irrevocable trusts for Medicaid planning purposes. That's a little bit more drastic. You have to give up basically control of your assets to put assets into an irrevocable trust. So assets that don't have a beneficiary or that are not in trust will pass according to your will, and any assets that pass according to your will are subject to probate. So that's a very brief summary of probate. I'll pass it to Chris. I just wanted to say that I know estate planning can seem overwhelming, but it doesn't have to be hard. It really just takes getting started and starting to think through a couple of bigger decisions, and things can come together pretty smoothly. So.
Thank you, Katy. Well, it's been said that estate planning is about everything you have and everyone you love. Other than that, it's really no big deal. All right. So thanks for including me in this evening's presentation. Given the topics that are being covered today, by the end of it, I'm sure that you all realize just how big a deal this really is. But don't be intimidated by it. I'll give you some advice that an old coach of mine once gave us right in the beginning of two-a-days, right? We have a whole, 30 days of two-a-days, the hottest time of the year, and everybody's looking at the schedule and go, God, how am I going to survive this? And he said, gentlemen, how do you eat an elephant? One bite at a time, right? Okay, so approach it in that way. And this advice certainly applies to trust. Don't be intimidated by trust. Trusts are to estate planning like what stem cells are to the body. They're kind of undifferentiated, right? They're foundational blocks that can be specialized as you go on to suit whatever the needs you have in your family, just like those stem cells do in your body. So what might be some of the objectives that you might hold? Well, it can be as simple as avoiding probate and guardianships by creating smoother transitions at disability and death. It could be protecting your assets from creditors, lawsuits, divorce, long-term care costs like Medicaid spend down. You can provide personalized instruction for the care of your loved ones, and you can reduce federal estate tax if that's an issue, income tax, and you can certainly fulfill charitable intentions. So these are just some of the common uses for trusts. But what exactly is a trust? Okay? So here's a nice short definition. A trust is essentially a set of instructions explaining how the trust maker wants a trustee to distribute income and principal to beneficiaries. So even though that's a brief statement, it does have some unfamiliar terms in it, so let's unpack it using a simple metaphor. When you were a kid, you might have had a little red wagon that you pulled around, right? And you put all your toys in it and you kind of went around the neighborhood with it. So right there, you have three important trust concepts. You're the trustee. You're the one that has the right to hold the handle. The wagon represents the trust, and the toys in the wagon represents all your stuff, your assets, your house, your car, your bank accounts, those sorts of things. And lastly, a trust contains instructions on who has permission to pull the wagon when you're not able to, and what's to be done with the assets that are within it. And a trustee has the highest duty according to law, okay? They just can't do whatever they want to do with it. They have to follow your instructions, okay? And it's a much safer situation than relying upon a power of attorney for that reason. So in short, a trust gives you greater control over your stuff under all kinds of circumstances, and they're all personal to you. So relationships are the key to our happiness, and they're the most important things in our life. You know, St. Paul said only three things last forever: faith, hope, and love. And the greatest of these is love, and love can only be found in relationships. And gifts strengthen relationships. And we can continue to give gifts through our estate planning. All right. First of all, having your affairs in order, as Katy had mentioned, is a huge gift, okay, to those who you leave behind. You know, not leaving a mess is a planning objective that's not to be underestimated. I just came from a funeral. I was out of town for a couple of days, and I'm the lucky trustee and executor of an estate that wasn't tied up the way it ought to be, and I'm kind of concerned about going into it because not everybody's going to probably be on the same page with things, and I'm not going to be right in the middle of it. And if you, the referee, in any kind of fights are able to prevent them, now's the time to do it. Okay. So what are some of the ways that you can give stuff to folks in your estate plan? Well, the first way that we do it through our trusts is that we call them specific distributions, okay? You can give an off the top sort of a gift. When you're paying the bills, you write St. Pius a check for $10,000, right? It's a specific gift. And it need not be cash. It can be items that might not have much monetary value at all. It could be something that has a high degree of emotional value. Grandma's pie plate that you inherited, and you're going to give it to so-and-so. And a nice thing to do would even be to write a little letter as to how you came by the plate and why you're giving it to so-and-so. It reminded me of the days that we cooked Thanksgiving dinner together or whatever, or similarly, a fishing pole reminds me of the time that we spent those long summer days catching nothing but carp in St. Joe River. And those sorts of things are very valuable. Even after the money's spent and you're long gone, they might have a blue day and simply reading that letter could be a really nice thing. So that's what we would call specific distributions. What's left over is called a residual distribution, and we usually itemize them by a percentage of what's left over or a fraction of what's left over. And you can give it to somebody outright, you'll just write them a check, or you can leave their gift in trust with instructions on how that trust is to be distributed. And it comes in handy because all of our kids, if it's going to kids, they're all different. Some are very good with money. Some will spend a dime when they only have a nickel, all right? And you could put training wheels on it if you'd like, okay? And then beneficiaries need not be simply your family. It could be charities. You could tithe 10% to St. Pius. Kids get the rest of the 90% that's left over. And lastly, it's a far-fetched situation, but what if all those other people that you've already mentioned predecease you, meaning they're no longer around? Okay, well, who would get it then? Okay, and you can do stuff like, I'm leaving it all to St. Pius, and you can tell Father Bill that I left everything to you. He doesn't have to know it's an ultimate beneficiary, but that's the sort of thing that you can do. And lastly, for somebody that really has a charitable intent, there are a number of different charitable trusts. There are just two that I'm going to mention. I think they're the foundation for the other variations that spin off of it. One's a charitable remainder trust, where a donor makes a gift to a trust, okay? And that donor retains a current beneficial interest is the term, right? So they give it to the charitable trust, they live on the income, and then when they pass, then it goes to the charity, okay? The other one is the charitable lead trust, where it's the opposite way, okay? Where the donor puts the money in the trust, gets nothing out of it. The charity, during the donor's life or term of years that are in the trust, by design, at that point, then it comes back to the donor's family, right? So you don't disinherit the kids while being able to help a charity. Now, charities would all prefer that you just write them a check, right? But there are ways that you do this, and one of the reasons you might do this is that you get a tax deduction for it, and they work in the term of years and your life expectancy and the interest rates to figure out how big a tax break you would get. And there are many other things that are the other guys over there, the financial guys that work on this stuff all the time. There are other things that you can do, but I would be remiss if I didn't mention another opportunity. Katy and I both serve on a board for the Catholic Community Foundation of Northeast Indiana. That's a mouthful. But the idea is they have a number of endowed funds that are a part of that all support the mission of the charitable ministries of the Diocese of Fort Wayne and South Bend. And St. Pius, when I looked at a more recent annual fund, there are 3 funds at the foundation that benefit St. Pius. And so that's all across the board. The seminarian fund's a big one. So that's an idea. If you have a charitable intent, you may want to talk to a representative there. So that's all I have, and I think we're going to watch a movie right now. Maybe it's just a short. Okay.
Thank you for leading into my video here. So I'm just going to show you a very short, 3-minute video of parishioner Peg Clays. She talks a little bit about exactly what he was talking about. So let me get you started here.
Good evening, I'm Mike Witous.
I had a question regarding the assets. We're talking about they could be sent to beneficiaries as long as everything is entitled to the beneficiary. Is that correct? Like a home, various financial accounts, as long as it was listed as as long as they were listed as beneficiaries.
Yeah, I think that's what Katy was talking about, TOD or peer.
Transfer on death. With what's called a transfer on death deed, so it's a document that gets recorded. You get it at the county state building.
No, any of the financial institutions where you hold your assets, they normally have a form that you fill out, and you can name transfer on death. So, for example, sorry?
Well, for real estate, no. Yeah, so, nope, it's a deed that, for cars you can do on your own at the BMV. So I would just call in advance because you know you always show up there and you need 1,000 forms you didn't think to bring. But it's a pretty easy process to have beneficiaries on your car title. And then for your home, you would need a transfer on death deed that adds beneficiaries on your property. So, yep, and I or any attorney, and I assume probably title companies could put those together. It's pretty simple to do. So.
And I have another question. Are holographic wills recognized in the state of Indiana? If you have a simple case, you're a widow, you have one child, there's not going to be any arguments.
I have not actually gone through the probate administration process, so I will let Chris address that.
Well, yeah, there's certainly formalities that need to be observed, right? And every state has different formalities. They're fairly uniform, though. Here in Indiana, you have to have 2 witnesses, okay? And then we take it a step further to make the probate process simpler by having a self-proving clause that follows that. And the same 2 witnesses sign that, okay? So you're golden to get the will into probate and start the process. The holographic will, how are you defining holographic?
Well, everything is where my daughter's the beneficiary, you know, except for I need to take care of the cars and the home. But there would be nobody to contest or fight it. She's the only.
She'd probably be your only beneficiary, but
So I
so
didn't
if
know
you
if they
hand,
would even have to go to probate or anything like that. If
it might not have to, as long, like Chris said, if you have 2 witnesses, that is the requirement for the execution of a will. but
Yeah, so holographic, she's meaning is,
Just written on your own.
you do it yourself.
oh, you do yourself?
Yeah.
Oh, yeah.
Holographic wills where
Yeah.
I'm taking this piece of paper right now, hey, everything goes to Maddie.
Yeah, so the elements
Sign
are,
it, date it.
obviously I'm in the business of creating wills, so not how to go around that, so I don't study it. I don't study that, but yes, yeah, you follow the formalities, and it's very helpful to say who's going to get what.
I wasn't sure if it was recognized in this state, though.
Well, you know, like I said, it's not something that we would study all day long because we're on the other side of the issue.
If you plan to do it, I would have 2 witnesses.
Okay.
To make sure that it would. And like you said, if your daughter's your only family member, probably not an issue, but it doesn't hurt to make sure you have those formalities in place, so.
Any other questions right now?
So again, I'm Mike Witous. I just want to let you know, I sent out an email to the group earlier tonight, and I said, you know, we wearing suits, or is it casual? And so they said business casual. I don't have business casual. And so Chris decided to put on a suit as well. But the interesting thing is we look like we're on a team, but we're not. We couldn't be wearing these for any further purpose. Chris is a University of Michigan grad, and he sees that as maize and gold. I went to Notre Dame. I see this as blue and gold. So anyway, I just thought I'd share that. So this morning, every morning my wife and I wake up, we do readings, have coffee. And after readings this morning, I said, Sheila, can I talk to you about my talking points? She said, sure. I never do this with my wife. So I went through my talking points, and she's like, do you intentionally do that? Intentionally do what? And she's like, you talk in fragments. You don't like complete a sentence. So I'm feeling really confident about my presentation right now. I just want to let you all know. And I think Andy is probably going to be our best speaker because anybody who follows me is going to benefit. So I'm going to start with a question. And the question I have is, what is the number one fear of humans? The number one fear of humans. What is it?
Public speaking.
It's right up there, along with money. The number one is actually death. I learned it last week. I used the Halo app, right? I guess Halo app was developed by a kindergarten teacher's son-in-law here at St. Pius. And they talked about that. So I thought it was interesting that that is our number one fear. So now a fact, the average American spends, they spend more time planning a 2-week vacation than they do their retirement or for death, right? Last time I looked, average American retirement is 20 years. Death, it says forever here. So it seems interesting that we don't plan for it. So what I want to do is go through my fragmented bullet points that my wife described, and I want to talk about 5 to-dos and 1 charitable gifting idea, okay? The first thing is another question. What is the Boy Scout motto? Right. So that is going to be a major theme here, right? 10 years ago, I was running a couple states for UBS out of Switzerland, and I was doing financial planning training for the advisors in the states. And the head of financial planning said, Mike, I don't see a financial plan in the system for you. I said, yeah, I've been in the industry 30 years, and I just don't see the benefit, right? So we said, well, I'd like to do one for you so I can reference it in intros and use you as a case study. I'm like, fine. So I did it. And 9 years ago, I had a heart attack. And sorry, every time I tell this, I get emotional. As I was in the gurney going into the OR, I thought, oh my God, is Sheila going to be okay? And then I thought, I just did that plan. Everything's, perfect. Everything is accounted for. Everything's titled correctly, so on and so forth. So my view on the planning process after 9 years ago is totally different. I'm a huge advocate of doing a financial plan. The reason you need to do it is to be prepared, to know what you have and where you have it, to know what kind of income you can generate for yourself in retirement, and to know potentially how much money you have to gift, okay? That was number one. Number two, and I should back up. There are 2 handouts in the back. I'm not gonna reference them, but you might wanna just grab them on your way out if you didn't grab them, because I'm gonna talk about the concepts. Number 2, don't leave heirs and family in the dark. Again, I've been in the business 30 years. I can't tell you the number of times where people didn't know if they had insurance, where the insurance was, if they had a will, etc. Do not leave your family in the dark. Let them know what's going on. Create a list of accounts, assets, contacts, your intentions, and discuss it with them. Number 3, consolidate your accounts. This seems like it's self-serving, but it's not. Having multiple brokers, banks, accounts is not diversification. I can't tell you the number of times where people are like, oh yeah, well, Mike, I'm gonna give you half the money because I'm gonna let Joe or Andy have the other half because that way I'm getting diversification. That's not diversification. What it does is it makes it very challenging for your spouse or your heirs. If I guess I'll leave you with, on this subject, if you don't trust your broker or your bank to give them 100% of your money, you're using the wrong one, in my opinion. Review your accounts, your assets, your home. See how they're titled, as we were referencing before, right? If you don't get a transfer on death on the accounts, get a trust established, so Chris can stay in business because he does trusts. Review and update your beneficiaries. Again, I can't tell you the number of times I've sat down with people and they have dead spouses. They have divorced spouses. They have brothers who passed away and they hate their sister-in-law. As beneficiaries, you need to keep this updated. So again, part of the financial planning process is you review this. Do a will, set up a trust if it's appropriate. Control your intentions and avoid probate. One of the things that Chris and Katy didn't address was the cost of probate. Somewhere between 4 and 8%. And secondly, and I think the more important thing is it's public, right? I don't know about you, but I don't want my assets in the South Bend Tribune. So the gifting idea, it's a charitable gifting idea. When I teed this up with my wife this morning, I actually put it in here. She said, so you should think of a donor-advised fund. Has anybody ever heard of a donor-advised fund? Okay, that's good. So nobody's actually going to challenge me on this. She said, so a donor-advised fund is kind of like a common person's foundation. And it is. It's very similar in concept, just usually done in lower denominations than foundations. So I'm going to give you 4 reasons you might want to consider setting up a donor-advised fund, okay? I work for Stiefel. The marketing materials I set out are Stiefel. I'm not promoting it. I'm here because Father Bill asked me to be here, okay? Andy can do donor-advised funds. The financial services company or banks that you deal with, they probably have access to donor-advised funds. So this isn't a solicitation on only Stiefel. I just wanted to be clear on that. So 4 reasons. Number 1, it's easy. You don't need attorneys, nothing personal. There's no cost. It's a simple agreement, no tax returns on it. The criteria is first deposit into the donor advised fund, it is $25,000. But from that point, it can be $100, okay? You have online access and it's very easily administered. Number 2, it's tax efficient. This is on the first handout that I have in the back. You maximize your charitable gifting. Donor advised funds are tax deductible, both if it's securities or cash. Okay, there are reasons you'd want to do securities as you get you don't pay capital gains on anything you may be putting in there. For cash, it's 100% deductible up to 60% of your adjusted gross income. For securities, it's 100% up to 30% of your adjusted gross income. And again, any monies you put into the donor or securities you put in the donor's advised fund, you're not going to pay capital gains on them. So as a result, the charity ends up with more of a gift. Number 3, make an impact. You can grant gifts to any not-for-profit, like St. Pius. No mandatory distributions on donor advised funds. There's a 25-year maximum distribution schedule. So you can put the $25,000 in this year, and you can pull out the whole $25,000 next year, or you can set it up for 25 years of $1,000. But again, there'll be growth, so they'll do it on a percentage basis. You have ultimate control on it, and you can change it. If your intentions change, you set up a 20-year schedule, and you ended up wanting to give it all right away, you can do that. The minimum check, because the way you can give your gifts is via check or you can have it wired, but the minimum check would be $100. So it's very user-friendly as far as being able to gift to multiple institutions if you want. The maximum would be 100% of the account. Number 4, legacy, and that's the second handout. Add your donor advised fund as the beneficiary or part of a beneficiary of your IRAs, 401ks, or estate plan. You can then name up to 20 nonprofits controlled by, because at this point it would be, if the monies go from your 401k or insurance or your 401k, it is post-death. So you can set up up to 20 institutions that will receive the assets, and your children will then be in charge of the vesting schedule at your death. As a result, you maintain support to the charity post-life. The monies, so you know, go into a 501c3. And Stifel's case, it goes into Stifel Charitable Incorporated. In the donor advised fund, if you have like a 401k or some kind of retirement plan where you have a list of funds that you can invest in, that's kind of how a donor advised fund works. You can choose whatever types of investments you want to put the monies in for additional growth for the more gifting. So again, you could stay in like a fixed account, or you could be aggressive if you wanted to. So with that, I'm done, and I'm going to turn the mic over to Andy.
Appreciate it, Mike. I'm Andy Hyduk. Mike wanted to talk to you a little bit about what to do during life. I wanted to talk to you about what happens when you lose a loved one, or what happens to your assets after death. I'm going to go out on what I think is a pretty strong limb and say everybody in here has lost a loved one. So what do you do? As you know, that can just be such a trying time. One of the best gifts you can give to your loved ones is to plan. Put that plan together so that when they're grieving, they don't have to think about another question that they have to come up with an answer for. You've already done it. Your wishes are known. So just from the financial side of things, loved one passes away. What do you do? From a financial side, you can't really start to do anything until you have a death certificate. First and foremost, once you get those death certificates, make sure you get plenty of them because you're going to need them. So nothing on the financial side can really start, generally speaking, unless we have that. So we start there. Then hopefully, as Mike was talking about, taking that inventory of the assets you have. Hopefully, if you've done the planning, you have a list of all your different accounts or different assets that you have there. So your loved ones don't have to go on a treasure hunt. I know there's lots of fun adventure movies out there of the treasure hunts and all of that, but at the end of the day, it's one of the biggest blessings you can give to have that all planned out from there. And it can be a nice, smooth process then. Mike was talking about, sharing that with whoever that executor may be or trustee, or depending on how you have it set up. Because then you know what items need to be addressed and where. Do we have to contact the Social Security office? Do we have to contact the bank? Do we have to contact a life insurance company? Do we have to contact the financial firm that has their various brokerage accounts, their retirement accounts? I'm sure Mike probably does it as well. I love taking the inventory with clients so that we have it there. And at the end of an appointment, we hand them that paper and say, here, keep this with your safe documents, the documents that Katy or Chris have created for you, because you don't then have to go on that treasure hunt. Our name and numbers at the top, call them. They probably know something can help you through that process, because at that point in time, it's a trying time. So really then what starts to happen to your asset? What happens to those assets if they're your assets, or in this case, let's say you're the one who's responsible now for your loved one's assets? There's two different categories I like to talk about at this point in time. That would be non-qualified versus qualified. Really what comes down to the difference there is taxation. Now, being a financial advisor, we are not allowed to give tax advice, but we're certainly going to give a little bit of education along the way there. Because it was kind of fitting this past Sunday, we had a gospel about Caesar and giving taxation to Caesar and all that sort of stuff. But little apropos from there, because at the end of the day, your hard-earned dollars, our job as financial advisors is to make sure you pay your taxes that you owe, but to keep as much of that money in your pockets for your loved ones, for those charitable causes that you might deem worthy of your hard-earned dollars that you've worked so hard for. So the main thing, when you pass away, some of those assets in the non-qualified meaning assets that don't have special tax treatment. So think of that as your checking, savings accounts. Think of that as just a regular brokerage account, non-retirement accounts from that standpoint. Usually upon death, they get a stepped up in basis, meaning that at the date of your death, that becomes the new valuation form at times, depending on some of those assets there. So then when you get down to, where you want to move assets, if we're talking about charitable giving, they've all of a sudden gotten a step up in basis, so maybe that might not be the best asset that you have to donate it then at that point in time, because your heirs, your children, now their basis has changed there. Whereas opposed to your qualified assets, which would be your retirement assets, think of your 401ks, your traditional IRAs, from those perspectives, those don't receive a stepped up in basis. Those still, when you withdraw money from them, are still going to have to pay taxes on those. And so if say you could do, while you're living, you could do what is called a qualified charitable donation from there, where you can give it to a charity. You don't have to pay taxes on that. It counts as a donation. So rather from that, so a little bit of a workaround. Certainly contact your CPA or whoever handles your taxes about that aspect, but any of the financial firms can handle those from that perspective. When it comes to your retirement accounts, traditional IRAs, those would be pre-tax dollars, meaning that those dollars have accumulated without paying a dime of taxes on them. All right, and so death and taxes, the two certainties of life. I'm sure we've all heard it plenty of times. Those, when they pass on to your heirs there, when they will then have 10 years now to draw down that account to zero. So depending on how much money is in there, that could be a significant increase in ordinary income for your heirs. Let's say you have children who have done all right in life, have a good job, good paying job. Maybe it's not the best thing for them to be increasing their ordinary income. So maybe your non-qualified assets go towards them. The qualified assets, maybe if you're charitably inclined, those go towards the charity of your choice there from that standpoint. But like I said, the qualified assets, if they do go to a non-spouse, you do have 10 years now to draw that down. They did just change some of those rules. I think it was back in 2019 when we had all those different litany of Secure Acts and all those sort of things that came about from that perspective. So those are some of the main things I wanted to touch on. Really, it all starts with the death certificate. Have an inventory of your assets from there. And then really get back to why you plan. It's that last gift that you can give to your loved ones.
Somebody mentioned earlier about the endowments that St. Pius has at the Catholic Community Foundation of Northeast Indiana, which was set up by the diocese. So all the endowments that we have must go through the Catholic Community Foundation. We have the Monsignor William C. Schooler Endowment Fund that provides support for ongoing faith formation programs. We have the St. Pius X School Tuition Assistance Fund, and the Elaine Holmes Endowment Fund for Student Support, which supports training and services for children with unique learning needs. So those are the three endowments we have right now.
And just information, the Knights of Columbus also has an educational endowment fund.
Thank you. Well, I would like to thank our panelists again for taking the time and coming here. And to thank all of you for your interest. And if there's anything that we can do to help you in the Stewardship and Engagement Office or in the business office, please let us know. If you know people who have not been able to come, sessions 2 through this one will be on our website and on YouTube, I believe, that you can easily find them and we can direct them to them. So thank you again and have a good night.